Okay, I'm Doug Mullally, President of the Bruce Power Pensioners Association, and I want to thank everybody for coming out today. And quite honest, we were overwhelmed with the response we got on this seminar. Well over 400 people registered for it, pensioners and spouses, and we certainly were shocked by that number. We moved the venue 3 times now to be able to accommodate the numbers. So thank you very much for your patience. We'll get back to you with the final venue. This is obviously a very important topic for everyone, just from the response we got. And I think the majority of us probably have done some estate planning. We've done some things with our wills. But one thing you should be doing is going back and reviewing that on a fairly systematic basis. I look at myself as an example, and we set up wills some time ago, but it's probably 20 years since we reviewed the wills. So obviously things have changed. Executors will change. So I think it's important that everybody just sort of refresh their estate planning plans, just to make sure they're up to date. And not so much for you, but for your kids that are going to inherit your estates and spend all your money that you earn. Now, we've invited Meridian Credit Union to put on this seminar for a few reasons. First of all, they have a long history of working with previously Ontario Hydro, OPG, and now Bruce Power. There was certainly a strong link between HEPCO Credit Union, when I go back in the late 70s when I was starting to work, and employees of Ontario Hydro at the time. So it just seemed like a good fit for continuing this discussion. Now, I'm sure any of the other banks that you deal with could put on the same similar presentation, but we chose Meridian just because of the history of dealing with them in the past. We're lucky enough to have Doug Carroll, who's going to be our speaker today, and you saw his resume, and I think someone will probably go over it again today, but he's got a wealth of experience in estate planning, and we certainly want to pick his brain for the next hour or so on that. I do want to introduce a couple of people, I guess. Kevin Morris, who's the Regional Wealth Sales Manager. Kevin, you can just wave your hand. He's at the back there. Kevin worked with us in organizing this, and he's been very, very helpful in pulling this together. I certainly appreciate his help. We also have someone from Bruce Power, Human Resources, Lori Hill, is at the very back. So she's a young-looking pensioner there sitting on the back, blonde hair. But she'll be running a questionnaire type desk out between when this session ends, so you can talk to her outside if you have any questions on benefits and that sort of thing. So it's an ideal time now to get those questions answered. She'll be set up at one of the tables outside after the session is over. So I appreciate Lori coming. Thank you very much. And obviously our local branch manager, Port Elgin, has joined us today, and we certainly want to introduce her. It's Erin Eldridge, who's just taken over the branch, and certainly welcome her to Port Elgin. Well, she's a Port Elgin native, so I guess I really can't welcome her here, but I appreciate Lori. So she'll be the contact at Port Elgin Meridian branch these days. I should say one other thing, because we do have 2 sessions, the second one starting at 3:30. So when this session breaks up, appreciate it if people could leave on a fairly orderly basis so we can get the other people in and clear the parking lot for one group and allow space for the next group. Also, during Doug's presentation, I appreciate it if you could just hold your questions until the end of the presentation. It just makes a smoother presentation for all. And if you have a question, but it's somewhat personal in nature, which you don't want to share with 200 and some people, Doug and the Meridian Financial Advisors will be around after the meeting to answer those types of questions too. So again, if you have a general question, just hold it to the end of his presentation. And if you have a personal question, then speak to Doug or one of the other financial advisors directly.
Thanks everyone for being here. Again, we were overwhelmed. Thanks, Doug, for making the arrangements for people to be here. I am going to briefly run through this. Jason mentioned the type of approach that we take at Meridian with wealth. There is a page in your folder which has this same image on it, and I just want to touch on this briefly. You won't be able to read it up here, but you have it in your material. It's the approach that we take where we look at our members from these four quadrants, looking from the top left-hand side, the day-to-day needs that you have with your financial world. So those would be things like having a place to put your money, having accounts to put your money into, and then from there over to the top right-hand corner, we've got the availability of credit, being a credit union, and then as you go down to the next quadrant, down the bottom right-hand side, there is the section that says investments. And that's really where our wealth people operate, is in the investments area. And we do look at the way that we deal with our members' money in that fashion, from the day-to-day over to the much longer term. And then as you come over to the bottom right-hand side, the one that says protection there, that's about making sure that not only is the money itself doing what it is that you want it to do, but also you are then able to pass on to the people around you, taking care of yourself and the people around you with the money in the appropriate way. And that's what we're talking about here today, is estate planning, what you're able to do with what you have accumulated to make sure that the right people receive the right things at the right time, all of that type of need that we want to help you deliver on. The next slide is a rundown on the process we take with our members, where we do go through a financial planning process. And the only thing I'll say about this is that historically, decades back in time, stockbrokers had the image of selling whatever it is they had to whoever might want to buy it. A financial planning approach looks at you as the person, what your needs are personally, what your goals are, and then looks to fulfill on those goals by having financial strategies that will help you get to where you are going on a personal level. So I'm not going to go through these 7 steps. Again, it's that page. I think that some of you don't have that page in the folder, may have a stapled bit. This whole line of people, you got the ones that didn't have it. We don't. But you're certainly welcome to it, okay? It's just those 2 pages. It's to make sure that people are aware that this is the way that we approach things. So let's leave that aside, because that's not the core content that we're dealing with here today. What we're dealing with today are these handful of topics. There is on the left-hand side, or in the stapled bunch that you have there, a blue page, which is an agenda of topics that I'm going to touch on here. The text that is going to appear up on the screen is about this size text. So hopefully that those of you who are further back won't have trouble seeing that, but you won't be seeing tiny little text coming up here. I'm going to deal with these half-dozen topics. I'm just going to grab it myself here. This is the page that I'm talking about, which is the agenda. So pretty much what you're going to see up on the screen is on this page that you have in your hands, so you can look down if you can't look up and see what's up there. So these are the topics I'm going to deal with. There's one thing that I want to touch on first in terms of estate planning and being conscious of planning. This is an image of something which is related to a case from the late 1940s. And what happened here is this fellow, his name is Cecil George Harris. Mr. Harris was a farmer in Rosetown, Saskatchewan. He went out one morning to go plow the fields. I'm not a farmer, so I'm not going to try to give another version of what it was he was doing. He was on a tractor, he was heading out there. He didn't come back that night, and so his wife called up the neighbor, and they went out looking for him, and they found him underneath the tractor, unfortunately. He had managed to get caught in some mud. It was a rainy day, and he had turned it over on himself, so he couldn't move pretty much. They took him to the hospital, and unfortunately didn't survive. When the neighbor came back the next day to bring in the tractor from the field, he saw the etchings in the fender of the tractor and called up a lawyer and said, "I'm seeing this thing." Lawyer said, "Bring it in to us." And they brought it into the lawyer's office. It was scratched into it with this pen knife, what Mr. Harris had done. "In case I die in this mess, I leave all to the wife, Cecil George Harris." This was offered as his will to the court office. It was accepted as his holograph will. So in his own handwriting, so to speak, etching, it was made available to the court, and it did in fact govern what happened with his estate. The benefit of this case actually, if you Google it or you search on the internet, you'll find this case being in article after article every month or so somewhere around the world. They talk about this as being the most famous holograph will in your own handwriting. It is very important that he did this in this case because if you think about the time that's involved, about half a century or so ago, had he not done this, then his wife would have had a much more difficult time dealing with the estate. She would have been somewhat bypassed based on the rules that existed at that time, where she would have had to go through a lot more hassle. So he did her a big favor by doing that. That said, please don't do do-it-yourself wills. And don't do do-it-yourself wills this way. If you're in an urgent situation, then doing a handwritten will might serve some immediate purpose. But I do encourage you, if there's nothing else you take from this, I do encourage you to engage professionals to work with and make sure that they cover off all of the considerations that go into estate planning. And that's one of the things that I want to emphasize, that estate planning is somewhat seen as, if I have a will, I have an estate plan by a lot of people. But having a will, though it is very important and it is central to your estate planning and the carry out of your plan, it is not in itself an estate plan. The perspective that I like to emphasize is that estate planning is about the people, not about the documents themselves, although the documents are critically important. It is about the people. Who are the important people around you who you want to take care of? And that starts with yourself. So when you're talking about estate planning with the person that you have breakfast with across the table, or just thinking through it yourself, it does involve you in your estate planning. It's about taking care of yourself as much as it is about taking care of the people around you. Everyone's been on a plane, or most people have been on a plane, and you know what they say: if that air bag drops down, then put your own mask on first before you put on the children who you're taking care of. Well, similarly, you have to make sure that you're taking care of yourself in order to be able to take care of the important people around you. So my definition of estate planning, apart from what people would think about estate planning being, I've got a will, I've got an estate plan, that really only speaks to one point in time when you're no longer there. My definition of estate planning starts with you, saying you want to take care of yourself now and in the future, and take care of yourself and the people around you now and in the future, and also in the future when you're no longer around to be involved with those people who you care about. So a will does deal with that very last stage of things and is very important to make sure that your wishes are carried out, but it's only part of the whole consideration and discussion. The property that passes through your estate is not in itself of value. It's only of value to you if it is supporting the kind of relationships, the people who you care about. So move away from a focus on the stuff. Look at the people and how the stuff in its transfer to those people, the accumulation of things that you have built up over the course of your life, will help fulfill on what it is that you're trying to do in your estate planning. So it starts with you, about yourself, and then in doing this, you have others who might be involved, professionals who you're going to work with. Lawyer as the center of that. I mean, classic estate planning. If you look at who does estate planning, I think most people would first come to mind as professionals. Lawyer who's doing that. But also, there are other professionals who have a very significant contribution into your estate planning, intentional or not. And those professionals would be an accountant or a tax professional who's assisting you both in terms of your taxes on a current basis, but also making sure that you're aware of tax implications that happen when you die or at the point when you die, and whether there are ways to reduce that as tax liability concern, or to even possibly create tax opportunities for the people around you, either on a current basis or when you're no longer around. So the tax professionals definitely have some kind of an involvement, and also your financial advisors. The biggest decisions that you're going to make, dollars-wise, about the transfer of your property are quite often going to be who is going to be the beneficiary on my registered plan, so that's a pension or an RSP, a RIF, and who are going to be the beneficiaries on insurance. Those types of decisions, and they might just seem like they're a stroke of a pen, have very large implications. And more often than not, it's going to be the common back and forth between spouses and then equally among the kids that you're going to do that. And maybe you're just going to do it on the forms that are available from the companies who offer those things. But if you have more unusual circumstances, if you have somebody who's got a disability, if you're in a second marriage situation, if there are creditor issues that might be at work, if you've got maybe one of your kids has got a wonky marriage or is one possibly upcoming, all of those types of things, complications, could mean that doing those designations directly on the plan without thinking through the total implications could end up putting property in the hands of people who are not capable of managing it, or putting it into their hands and thereby making that property exposed to other claims in some way. So when you are talking about your estate planning, you want to make sure that all the professionals you deal with who have some kind of a contribution into this discussion are coordinated among themselves. What might work really well from a tax planning perspective might be antithetical to what you need to be doing because you got somebody who cannot come into the ownership of property for one of those reasons that I made out there. So that means that maybe you don't try to reduce your taxes as your primary concern. What you do is you make sure that everything is going to go to the right people at the right time with the right strings attached, and then after that, then you look down to reducing down the tax issues, perhaps reducing down probate tax. Those types of things then come into play at that point. But you get your priority in terms of who is going to get the things first. Again, taking care of yourself now and in the future, people around you now and in the future, and when you're no longer there, and then look at trying to reduce down the costs that might be associated with that. And then in terms of those beneficiaries, the idea that a will is the way that default your estate will be transferred on to people, that is going to be the bulk of it for most people. But where we have some of those hooks, some of those concerns that we want to deal with, maybe you look at transferring things on currently, transferring now perhaps, because it does make sense. You've covered off on who you're trying to take care of, and then it maybe makes sense transferring some things on a current basis, some things perhaps through your will, and where there are longer term needs where you need things to be taken care of for the benefit of those people, to protect them against themselves sometimes, then that's where the use of a trust might come into play, where you can have some continuing management of property for the benefit of those people who you're trying to take care of. So that's our people aspect of things. Now, I use this phrase, the method is the message, to harken back to Marshall McLuhan, and to mix a couple of metaphors here. There's, I think it was MacArthur's, the US general, who said, battle plans are useless, but battle planning is crucial. And that's the kind of thing that I think you want to think of here. An estate plan, there's no such thing. People will try to give a definition to, quote, an estate plan, but it's not that there is some kind of a binder you pull off of a shelf, which you blow the dust off, and you say, okay, here is an estate plan, I fill in the blanks, and then I have something which is universally considered to be an estate plan. It's not that. It's the process of estate planning. It's the process of looking at where you are right now in terms of your financial situation. Who are the people around you to whom you have legal obligation, moral obligation, connections, who you want to support, and then from here to where you might be in the future, how are you going to take care of yourself and those people around you? That's the estate planning process. Again, looking at the people and how the property that might be involved will be transferred to them. It's not about production of documents on its own. I'll come to the documents themselves, the key legal documents, but don't think of it in terms of, I've got now a will which is as thick as a telephone book. You guys can appreciate that when I say telephone book. You would not believe it when I'm talking to younger people and I get really blank looks from them, even at this point. But you get a document that has some heftiness to it, fair enough. But what you're paying for is the application of the expertise of the professionals you're dealing with, and most specifically, the lawyer who is going to assist you in doing this. So I use this phrase here, expert meet expert, to mean that if you are going to get the most out of any professionals you're dealing with, and in this case talking about lawyer, you want to be able to pull out from them what they have in this vast area of knowledge that they have, the things that are applicable for you. So while that person who you choose to work with is an expert in their particular area of law, you are the expert in you. So you have to meet the two of you somewhere in the middle. Be open with the lawyer who you're working with. You can't expect that if you've got some kind of unusual circumstances that doing a general plan will definitely deal with those things. You need to bring those issues out in the open, those facts out in the open, so that the lawyer can say to you, well, if you're trying to do that, then we can't do X, we need to do Y. Or if that's what you want to do, then maybe we need to make adjustments somewhere else with the other professionals you're dealing with the beneficiary designations. Again, the coordination of all the professionals that you're dealing with. That's the really important part of making sure that although each has their perspective, that they are dovetailing together to get to where it is that you want to get. And the starting point for that is your balance sheet. Now that may seem a little odd if I'm talking to you, and again my background is as a lawyer in practice. I ran a law practice doing principally estate planning work, focused on business owners quite a bit. But I would see people across the kitchen table, and I'd go and see them in their homes, and we would have this same kind of conversation, but more like a one-on-one, about what we were doing, what we were trying to achieve in our conversation. The starting point for that conversation is your balance sheet, is your financial grounding right now, because, again, I'll say it one more time, estate planning is about taking care of yourself now and in the future, and the people around you now and in the future, and when you're no longer there. So you need to know where you're at financially right now to know whether your intentions can actually be carried out. You may believe that you're able to provide each of your grandkids with $50,000 to go off to university, but if you're not there in terms of your finances where you are currently, then maybe you have to scale back your expectations. Maybe it is that you have to scale back your expectations for yourself and how you're living in your own life before you look towards passing on property to other people. As I said, I went and see people in their homes when I was running law practice and dealt with a lot of senior people who simply did not want to go to a lawyer's office. And I'll tell you, at least a half dozen or more times, I had people who I was speaking to who were well into their 80s who were concerned about their kids and if the kids were going to do okay. And the kids just retired from really good jobs with pensions. And here we got these parents looking at things and going, oh, I don't know if I can spend my money. And I'm not going to tell them, spend your money, but I felt like just reaching out to them and saying, hey, I'm not, it's your family, but you need to be taking care of yourself as much as taking care of those people around you who you care about. So get a good grounding in where your finances are to know how much you have available and then what kind of different planning opportunities might be presented to you in taking care of those people around you, depending on whether it goes through a will or otherwise. All right, so the documents, the key documents that are involved in estate planning. I'm looking at this from lawyers' perspective, all right? And these are the core documents that most people would look to put in place. The 2 powers of attorney and a will. And then I'm going to talk about trust because people hear the word trust all the time. It's regularly used in common language, and it's a common word that people use when we talk about interaction with one another. But I want to talk about it technically, what it is from a legal perspective and how it can be used. So the powers of attorney to start with. Powers of attorney generally are a subset of what's called principal and agent law, where a principal can name someone else to have legal authority to deal with the principal's property. It goes all the way back into the Middle Ages when, under the English common law, someone could name someone else to be the decision maker about the principal's property. In this case, we're talking about the subset of attorneyship. The person who grants the power of attorney, who is the owner of the property, is called the grantor. In some jurisdictions, they use the phrase donor. In Ontario, we generally say grantor, and that's what's in the legislation. The grantor gives the attorney, the person who is named, the authority to make decisions about the grantor's property. So that's how it existed under the judge-made law, the common law. It's since been brought into legislation. It's governed by the provinces, as between the federal government and the provinces. It's under provincial law. The key legislation is what's called the Substitute Decisions Act. And when it was brought into legislation, prior to the Substitute Decisions Act, which existed as of 1992, one of the things that was a concern about powers of attorney under common law is that the power given by the grantor would cease to be effective once the grantor becomes incapable of dealing with his or her own affairs. Well, in the modern world, the point at which we generally want that attorney to be able to act is usually going to be when the grantor, the giver of the power of attorney, becomes incapable of dealing with his or her affairs. So with the Substitute Decisions Act in 1992, it introduced what's called a continuing power of attorney. Continuing means that when you make out the power of attorney, in the document, you can state that that power that you give to that person is operational on a current basis, if you want to state that it's immediately effective, and you can add that it will continue to be effective if you are incapable of dealing with your own affairs yourself. So that allows that person to step into that breach, to make decisions about your property for your benefit, subsequent to you being incapable of dealing with things. And that could just be that you are comatose, unfortunately, if there's some kind of an accident, or it could be declining mental capacity that leads to that situation. That's the power of attorney for property. The other thing that got introduced in the Substitute Decisions Act is another type of power of attorney, which is the power of attorney for personal care. The difference between them is that the power of attorney for property is about the stuff, the power of attorney for personal care is about you personally. So you can name someone who can make decisions about you, about where you're going to live, nutrition issues, about your hygiene, about your social arrangements, all the things that are about you, healthcare decision making generally, as well as medical consent very specifically. You don't have to name two different people as power of attorney for one purpose and power of attorney for the other. And more often than not, between spouses, you will in fact name the other person in both respects and likely as executor of your estate as well. But you could break it down a little bit, and certainly if you are the survivor of the two of you, or if you just do not have children and so you don't have a spouse that you would be doing that with, then you're going to be looking to others, to your children perhaps, and deciding among them who might be the appropriate one to make decisions in these different scope of responsibilities, the things you have, and then you personally. Both of those documents, the powers of attorney, both of those documents operate while you are living. They cease to have any effect once you die. From the point that you die, the familiar document that everyone would be aware of is a will. A will speaks from the point of your death. It gives you the opportunity to say who is going to receive those things that you own in your name alone at the point of your death. And it also gives you the ability to name someone who will carry out the responsibility of executing the will, and that's your executor. And that's where that word comes from, executing the will, executor. So that, again, most commonly between spouses, kind of the default arrangement most often would be that you would name one another, but you certainly can name other people who would do that, or you could name a corporate trustee who could act as the executor of your estate. So those are the three core documents. The last item I want to touch on here is to look at trusts. A trust is an arrangement where, for one reason or another, you have a concern that the person who you want to transfer property to cannot or should not have full entitlement and full power over the property that is going to come to their benefit. And that's where you could set up a trust. The easiest representation that I can give for a trust is to look at it as being a triangle. So think of this triangle. Up at the top point of the triangle, it's someone who has some kind of property. And if we're talking about setting up a trust out of your will, all of the property that you own at the point of your death falls into or forms your estate, and you, as the person who made out the will, are the person at the top point of that triangle. And what you're doing with a trust is you're dividing out legal ownership, as in title to the property, across one line. So there's our bottom corner, there's you up here, and then we're going to name someone who's going to have the legal authority to deal with the property, and that person is your trustee. And then over here at the other point of the triangle down this corner, that will be the beneficiary who will ultimately receive the property that we're talking about. So the interior of the triangle is the property which is at issue. We've now put a trustee with legal ownership in charge of that to manage that property, looking at the best interests of the beneficiary who will ultimately receive the property, both the income of the property and the ultimate distribution of the property itself, the original contributed capital. Now, we can have more than one trustee, we can have more than one beneficiary. These things can get much more complicated, but the simplest representation is to look at it as being that kind of a triangle. You can actually set up a trust during your lifetime. It's called an inter vivos trust. Or you can set up one, as I was saying, through your will, and that's referred to as a testamentary trust. It used to be that there was some very significant tax benefit in setting up the trust through your will, testamentary trusts. There still are lots of good reasons to have trusts in your will as a safety net to capture things that may not have been completely dealt with in the will directly, maybe because you've got beneficiaries who are underage that you don't know about at the date when you make out your will, but then someone has another child, and so you want to make sure that it captures their interest and the property is managed for them. So a trust that you create in a will still has very important need, but the tax rationale for doing it, which existed in the past, is not really there very much anymore. And the tax rationale, just not to be too cryptic about it, you and I are taxed at marginal tax brackets. You pay low tax rate, or well, relatively low tax rate on the first level of income you have, and as you move up through income levels, you pay higher tax rate on higher levels of income. Well, in a trust, under a testamentary trust in the past, what would happen is it would also get that same kind of low tax bracket treatment and then move up through tax brackets. That is still available where the beneficiary of the trust coming out of the will, or the testamentary trust, is a disabled person. So that still can be done very much for people with disabilities, and there are other circumstances that might allow you to make use of trusts in that manner. But otherwise, trusts, whether they're created during lifetime or out of the will, end up being taxed at top marginal tax bracket, which is over 50% here in Ontario. So setting trusts up to try to reduce taxes is not as common as it was in the past. There may be places where it can be worked in, but don't believe that what existed in the past, and when I say the past, this is 2015 back, the benefits of setting up trusts in a will are not so tax beneficial as they were at one point in time. So those are the documents. Once you have taken care of the planning, so in terms of the priority of things, once you've taken care of yourself and the people around you, that the plan makes good sense, then that's the point at which you can look at cutting costs. One of the really dangerous things that people get into is the notion that probate is the priority in your planning. Well, probate is an unfortunate cost that might be associated with managing a will, and certainly where you own property in your own name alone, particularly real estate, that falls into your estate, almost invariably a probate application will be required. So let me explain what probate is. So as the executor of the estate, the person who is named as executor will take the responsibility of gathering in the assets of the deceased person, making sure that those assets are protected, doing all the administrative work involved with the estate, like paying creditors and protecting the property, insuring as necessary, filing the taxes on behalf of the deceased person, completing those responsibilities, and then ultimately distributing out to the beneficiaries who are named in the will. In order to gather up the property that belonged to the deceased person, though, there will be third parties out there in the world who will not know this person who is the executor and will want confirmation that the named executor can in fact operate under this will. Some of those people or organizations may be quite content to say, yeah, we know you, we've dealt with you, and so we're going to turn over the property that belonged to the deceased person. But where there's significant assets involved in the tens of thousands of dollars with financial institutions, for example, or insurance companies, then they've got to be careful about how they do things on an official basis. So they'll want to have proper confirmation that the will that the executor is holding on to is in fact the last will, that there hasn't been a later will that's been executed, that this is not a fraud in some way. And so they'll ask for the executor to probate the will, which basically means that the executor will fill out the appropriate forms with the Ontario court to be confirmed that this will in fact governs the property of the deceased person. And once the court is content that, in fact, the will does govern things, then the executor can take the document that they receive back, the certificate confirming that the will is in fact the last will, and then go to the people and the organizations that have the property of the deceased person and compel those properties to be turned over to the executor. So that's the probate process. The cost of doing it, and they're just changing this actually in the Ontario budget, it's been proposed, and I don't suspect anybody's going to complain about this. The cost, as it has been for quite a while, was 0.5 percentage point on the first $50,000 of assets, and then 1.5% on everything over $50,000. What they're changing in the budget is just to get rid of that first $50,000, 0.5 percentage point. So there's no probate tax that applies to the first $50,000, assuming that they pass this budget, and they're in a majority, so it likely, in all likelihood, will pass. And everything above that, 1.5%. So keep that in mind. 1.5% of the value of the property that goes through the estate would be subject to probate tax. It can be a large absolute dollar figure. At $1 million, leaving out that first $50,000, we're talking about $15,000 per $1 million of assets. But percentage-wise, it's never more than 1.5%. And people will jump through hoops trying to avoid probate tax and possibly making all sorts of grief for themselves as well as for the people around them, and particularly through the estate, by trying to maneuver around this probate tax. I'm not suggesting that you say, yeah, let's pay as much as possible, but just make sure the plan makes sense of who's going to get what and when before you start trying to cut down on the costs. So some of the things you can do: designating beneficiaries on all of your plans, your registered plans, RSPs, RIFs, pension plans, insurance of various sorts, life insurance, maybe some other insurance that you may have. Designating beneficiaries, the funds coming out of those plans will make sure that they go directly to those people and does not fall into the estate. So that's one of the common things you can do. Using joint ownership. This is probably the biggest sledgehammer that people try to use to avoid probate that can get you into more hot water than can relieve you. But joint ownership, there's two types of ways generally that people can own property where there's more than one person on title to the property. When I say property, I mean real estate as well as personal property like an investment account, for example. So you can have joint ownership where you have an equal undivided interest in the property. I'll just stick with the real estate because I think that's the one that is the easiest one to understand. Between spouses, it's pretty common that you will own your house in joint ownership and maybe the cottage as well as maybe a second property. Under a joint ownership arrangement, when one of the joint owners dies, then the other joint owner or owners, can be more than two, continue on in their ownership of that property by right of survivorship. So the interest of the deceased person does not fall into that person's estate, it goes over to the other joint owners. Between spouses, that probably makes perfect sense because that's probably the main, if not the only beneficiary out of your estate in most cases, and so we can make things more efficient by using joint ownership. The other type of way that you can own property with multiple people is what's called tenancy in common. Under a tenancy in common arrangement, your interest falls into your estate. So my brother and I, for example, if we owned a rental property together, we own a condo that we rent out, and he put in 80% of the money and I put in 20%. So we decide that 80-20 is our split on that thing. Much as I like him, I don't want him to get my 20% when I head off in the beyond. That's to go to my estate for my wife, for my kids. So my interest under a tenancy in common, if that's the way that we held the property, would go into my estate, and that is where the distribution would be dealt with. So that's the distinction between the two. What people get caught up in sometimes is looking at the probate tax, because if on the joint ownership, if the interest goes over to the other joint owners, then why not do that with your kids as well as doing it with your spouse? So we have one spouse dying, we've got the surviving spouse, mom we'll call her, as the only owner of the property at that time. Why not add on son as joint owner on the property as well? Because then we know that should mom die or when mom dies, the interest goes from mom over to son without falling into mom's estate, without being subject to the probate tax. Seems like a good idea, and it may be unproblematic in some situations, but here's the implication of it. Whereas spouse to spouse, you can roll over capital property between the two of you, with a non-spouse, you can't do that. So you actually have a taxable disposition at the point of adding a non-spouse onto a capital property. If it's your principal residence, mom's principal residence, that may not seem like it's a big concern because mom doesn't pay tax on the gain in her principal residence. She adds son on and nobody pays any tax on that. That seems okay, except that mom lives for another 15 or 20 years, and unfortunately, she only has a joint interest in her property. Son, who owns his house down in Hamilton, also owns as joint owner on mom's house. So when mom dies 20 years down the road, half of the growth between the point at which son was added on until the point when she dies is protected by the principal residence exemption. The other half is taxable to son, okay? So that's not a good result, and I'm not giving all the timing of things, but that's the net implication of it. And if this was your cottage, even worse on the cottage, if the cottage was not your principal residence, mom's principal residence, if she had bought the cottage for 200 grand and it was worth $1 million when the husband died, and then she said to herself, I think I'm going to add my son onto it, that on transfer to joint ownership between herself and her son would by default be a disposition of half of the interest in the property, so you'd have a $400,000 capital gain in the example. I think I gave that correctly. $200,000 cost base, $1 million value, half of it's deemed disposed, so you'd have a $400,000 capital gain that by default would arise if you were not careful about how you recorded the transfer. Are there ways to get around this, to not have those problems? Yes, there are, but they have to be properly papered at the time that you are doing these transfers to make sure that that does not happen. And those types of additional steps involved may not be desirable. So you just want to make sure that you're clear on what this is. Avoiding a little 1.5% tax can be very problematic if you're trying to use that sledgehammer of joint ownership. Between spouses, probably the default. With non-spouses, make sure you get legal advice and you get tax advice. And the last item here is lifetime gifts. If you don't own things at the point of your death, they don't fall into your estate, they're not subject to probate tax. I mentioned that a number of the people that I saw when I was running law practice were older people who were, I was seeing them in their homes, and it came up many times, the idea that what if I transfer my house to my son's name because I know he's going to take care of me, he wouldn't kick me out. I'm not going to disagree. I don't know her son. I'm not going to disagree with that idea that the son is not going to do that. But come back to why you're doing your estate planning or who you're doing it for. You're doing it for yourself first, and then the other people around you. The other thing is, I'll just give you one example of how this could go sour. Let's say you put your son, or you transferred your property to your son. Again, because you're trying to avoid the probate tax, it's almost always driven by the probate tax as this major concern. You put the property directly into his name and you're no longer on title to the property, you know that probate tax will not apply then upon your death. Wonderful. Unfortunately, your son has an accident himself and he becomes incapable of dealing with his affairs. The person who is managing his affairs must use his property for his benefit. Your house is his property now. That presents a really difficult family situation should something of that nature happen. I'm giving you a real extreme example of that, of how it can go bad, but just be very careful about transferring excessive property to other people who you do want to take care of at points when it's not really necessary other than to try to avoid the 1.5% probate tax. So keep things in proportion that you don't end up causing peril where you're trying to save this small amount of tax. So getting it all going, Great intentions. People will say, yeah, I got to do my will. I got to do my will. I'm sure you've said that to yourself. Yeah, we got to get to that, doing that will. And I'm sure that some of you have wills that have been done in the last 6 months. Some of you have wills that were done 25 years ago. The one person I had was a guy who actually lived up the street, an older fellow who lived up the street where I grew up, first little while that I was in practice. And when he died and his will, so this was in the 90s, his will was actually from 1932. And it named his brother, who had died sometime around 1950, as the executor of the estate. And sometime between 1932 and 1998, he probably should have changed his will a half dozen times because of major life events. But as it turned out, it served its purpose, and his wife then acted as executor. But it is something that you should make sure that you do when you have major life events. There's one of the pieces, Doug, you had it on the table there, which is the estate. There we are. Estate reference guide for your executor that the association has. It allows you to then put down information about the important people around you, so that you're giving your executor a starting point with who are the people around you and the main things that you have. There's also in your kit, we have our financial planning workbook from Meridian that we've included there. We have an even more detailed estate planning form, which is similar to the form that we have here that I just held up. So getting your wishes down in a place to give your executor the opportunity to start into things is a really good idea, because they don't know you. Even the person who you live with, again, you have your cornflakes in the morning, may be challenged to figure out everything having to do with you. So make sure that the person you name as the executor does have a good starting point by recording information as much about yourself as you can. Communicating with the people around you. There is nothing that legally requires you to tell anybody that you are doing your will or doing your will over again. To the extent that you're comfortable with it, though, it's a good idea to communicate with the people around you so there's some level of awareness, because what you think is the appropriate way to go about things may not actually carry out that way, depending on things that you don't know about. You might think that your daughter is the person who is the most organized and really needs to be the executor of your estate, and so you're going to name her and you're not going to ask questions about it. Well, unbeknownst to you, perhaps she's not comfortable with that. She's happy with dealing with things where it's just straight businessy, but when it comes down to the emotional part of it, it might cause an enormous amount of stress. So communicating to some level with the people around you will allow you to just make reasonable certainty that what you are planning to do actually makes some sense. So that's in terms of naming an executor in that example. Another example of that would be a situation where maybe one of your kids has had a harder time in life, and so you've got 4 kids and you want to give more to the 4th one that's had a harder time, and a little less the other 3. And that might make perfect sense to you, and maybe it makes perfect sense to all of them. But on the other hand, maybe the reason why number 4 has had a harder time in life may be things that person brought upon themselves that are somewhat unbeknownst to you. And by giving them more than the other 3, maybe that's going to cause more of a problem with them after you're not around, because they all keep the gloves off when mom and dad are around, and then when mom and dad are out, they just go, time to go. So maybe what you are intending to do doesn't make sense. Again, I'm not telling you you have to tell everyone everything that you're thinking, but just field those possibilities so that there aren't surprises after you're gone that cannot be corrected for directly by you. You may have more of an opportunity if you're involved with the conversation beforehand, and then adjusting what you're going to do with your planning then. And then the last item is just about reviewing your will. All of your affairs should be reviewed from time to time. Financial advisor you're probably seeing at least once a year for financial matters. But in terms of a will and the power of attorney connected to it, connected to you, I say that there are 3, let's see the order that I have this in. Okay, there's 3 of them. Periodic, possessions, and then people. So 3 things that are prompts for making a review of your will. Not making a change, but at least looking over it. The periodic aspect, people will say, oh, you need to do your will every 2 years, or every 6 months, or every 20 years, or something like that. I say every 5 years is an appropriate time to look at, and here's my reason for it. I mean, the numbers are somewhat pulled out of the air, but in the combination of these three considerations, it should cover you off on the need for change. The reason I say 5 years is because in a 5-year time period, you will have had at least one and possibly two elections, provincially and or federally, and a change of government may mean that a different perspective on laws might be brought in. Now, we haven't had something in the last 3 or 4 years, but 5 years ago, I mentioned the change in the taxation of testamentary trusts, which came into play in 2015. So if you did your will prior to that time, if you did it 10 years ago, the lawyer who you were dealing with might have counseled you to set up multiple trusts for spouse, for kids, for grandkids. And there might have been a good reason to do that back then, which would only be complication now because there's no tax benefit to doing that. So that's at the federal level. At the provincial level, we had a change to the way that executorship is run. It's a little bit more onerous for executors now to carry out the job. There is more information reporting required than was the case 7 or 8 years ago. This started coming in 2012 or 13. And there are penalties associated with not doing the job properly that didn't exist before, including the potential to go to jail, although I've yet to hear of anything that happened in that way. But just the responsibility on the executor might be too much pressure for the person who you've chosen, and so maybe you should be looking at someone else or someone else in combination, or maybe even a corporate trustee. So those are a couple of things that as examples, arose because of a change of the law, which you had no involvement in. It has nothing to do with you. And so that's the kind of thing that you phone up the lawyer's office and say, hey, it's been 5 years. Has there been a change in the law, independent of me, that might prompt me to make changes? And of course, they're going to say, well, come in and let's sit down and let's have a conversation about it, rather than trying to figure it out over the phone. So that's the periodic aspect of it. The second item, and these ones are a little quicker, the second item is the possessions. If there's been a significant change in the property that you have from the time that you did your will previously, then maybe the distribution that you intended doesn't make the same sense as it did back then. If you've had a cottage that was going to go to somebody and it said it in the will that no longer exists, then that's a biggie. If you have had a significant drawdown in your investment portfolio because you're living your life and you had a beneficiary designation over to one of your kids on that aspect of things and the others were going to get something else, well, the proportions have changed now, and so maybe you want to rethink that. So change in possessions may mean that it's time to take a look at making adjustment to the will. And the last one, the most important one, is changes with the people. Again, what's estate planning about? It's not about the stuff so much as the people who you want to take care of. And when I say changes in the people, if there has been a birth in the family structure, if there's been a marriage, a divorce, if somebody's had a mental capacity issue, or even a physical health issue might have happened, if somebody has gone offshore or has gone to another province or vice versa, has come back in the other direction, if somebody's got creditor issues, all sorts of things having to do with the people, that may be reason that you should revisit what you've got going on. When I say the people, I mean yourself in some of those ways, as well as those people around you who will be beneficiaries or would be beneficiaries, and those who you've named to actually carry out some kind of a role like being an executor or being an attorney or being an ongoing trustee over some of the property that you have. So those are my 3 prompts: periodic, possessions, and people. That's as much as I'm covering here, and I went slightly over my clock time here, but I was close to it. I do want to open it up to questions that people might have, and we'll have to keep an eye on the time. But it's your floor if you want to jump up, and I'll repeat the questions as we're going here.
So your house goes over free for your principal residence, but your cottage, your second home does not? Or how does that work?
So the question is about, you were vocal enough, I think, but house goes over for free, but your cottage does not. So between spouses, you can roll capital property at its cost base between the two of you. If you want to add a spouse on, it is actually a taxable event, but it's a taxable event that has no taxes because it's a spouse who is part of that transaction. If you add someone on to ownership of a capital property, whether it's your whatever kind of real estate it might be, again, it's a taxable event. When you add a non-spouse on, and if that property that you're dealing with is your principal residence at that time, then you will not be taxed on gains on that property by adding that person onto the property. But if you don't want to treat that as your principal residence, then you've got a disposition on adding that person on. When I say, I'm just saying one, but we could have a number of people, like three. If you have 3 kids, you add 3 kids onto title of the property, then you're deemed to dispose of 3/4 of the value of the property when you do that. It's the nature of the property and whether you're claiming the principal residence exemption on the real estate, whether there's tax to be paid at the point of the transfer. But even if there's not, and this is where people say, what's the problem with doing it if I've just got the one house and I add on the adult kid to the title to the property? Yeah, no tax to be paid at that point in time, but you just gave up the growth in the value or some proportion of it back to the government, in effect, by having someone else who is not a resident in that property being an owner of that property. I don't know how helpful that was, because this gets a little bit complicated, but...
Okay, so if we both die and we want to give it to our children, what's the best way?
I'll never say best way to do any of these things. But on second death of 2 spouses, on the second death, then the property again is deemed disposed. If it was principal residence, then there will be no tax associated with that. It will fall into the estate of the deceased person, and then the distribution of that will go out to the beneficiaries of the estate, which would be your kids, whether they hold on to that property or they convert it into cash. So that's the usual way that likely your property would transfer. It is possible to set up a trust during your lifetime and transfer some or all of your capital property into the trust, of which you are the beneficiary during your lifetime, and then name others as contingent beneficiaries at the point of your death. That's called an alter ego trust if it's one person who sets it up, or a joint partner trust if it's the 2 who are involved. That creates more complication for most people than it's worth to do that. And so, again, not to invite probate tax, but generally probate tax is going to apply on the second death of 2 spouses, because the last person involved would own that property in his or her name alone. It would fall into the estate, and the land transfer office would not allow a transfer out of the estate without a probated will.
And the second property then?
And the second property,
The first one went over.
it would also fall into the estate. It's just that you would elect on which of the properties that would be the capital gain, which would be the principal residence, and which one would end up with a taxable capital gain, and tax would have to be paid on the capital gain in the estate then.
Are farms different?
I'm not even going to get into farms. Farms are very different. Farms are very different, yeah. So designated beneficiaries, if you designate a beneficiary on an investment account, then the money in the account goes directly to the person who is named as the beneficiary. Now, when I say that, a designated beneficiary can only be carried out with a registered plan. So an RSP, a RIF, a tax-free savings account, a pension plan, beneficiary designation on that. Whoever is named as beneficiary, and with the pension plan, it's a little different, because the pension plan, between spouses and survivorship, you would have the survivor as likely the carrying on. After a certain point in time, there is nothing left in the pension. But with RSPs, RIFs, TFSAs, if you name someone as the beneficiary, they get that amount that's in that plan. With non-registered investment accounts, you can't name beneficiaries. The exception to that would be if you have an insurance-based investment. So you hear about segregated funds. Those are investments offered by the insurance industry, which otherwise look very much like a mutual fund, but they are actually insurance-based, and so you are allowed to make a beneficiary designation on those types of insurance-based plans. Look at that carefully to understand what's going on there, because there is insurance associated with it, and so the cost of carrying that might not be worth the trade-off. In naming someone as a beneficiary on an RSP or a RIF, if you're talking about spouse, then generally everything can roll over from spouse to spouse on those registered plans without there being taxes applying at that time. If you're talking about non-spouse, then at the point of your death, all of your capital property and your registered investments are deemed disposed at that point, and they're brought into income in your terminal year, which is January 1st to the day that you die. So that's not going to matter much at all if you have, I'll keep it simple, one beneficiary who is the beneficiary of all of your estate that falls into through your will, as well as that being the person who you name on the various accounts as beneficiary. It's not going to matter to that person, because that person is either going to receive everything through the estate or directly through the plans, and any taxes associated with the plan will be borne by the estate, and it really doesn't matter all that much. Where it can be a problem, though, is let's say that you had a second marriage situation. You had a child from a first marriage and a second marriage, and for some reason you wanted to be intricate about how you provided for each of them. You decided that one of them was going to be the beneficiary on your $300,000 RIF, and the other one was going to get whatever was left over in the estate here, which you roughed it out to be $300,000. So that might seem like a good way to go about it. The problem is that when you name the one as the beneficiary on the RIF, $300,000 goes over to that person. That $300,000 is included in your terminal year and is taxed to your estate, which means that whoever's the beneficiary of your estate bears the tax liability on money that went in another direction. So that might not be a problem if you're aware of it, one, and if they get along, two, but it could be an unexpected distribution or reallocation that you weren't intending. So that's where I say coordination among the professionals you're dealing with is important, because if you want to make sure that the net money from the RIF goes over to the one as opposed to the other, then it may be necessary to have the money fall into the estate or use the will as the instructing document to make the beneficiary designation on the RIF over there. And that makes sure that you've pulled all the planning here together, and your financial advisor and your lawyer can then correspond to make sure that that happens in the appropriate way. Okay, so this is a situation where you, as child of an elderly parent, have been at some point in the past added on to be joint on that account. You, for the sake of our records, for Meridian's records or a bank, if that is set up as a truly joint account, then on the death of one of the joint account holders, the other continues on. There may be a necessity to prove the death in order to properly record the continuing access to the account, but that does carry over to you as the survivor. That said, and this is probably much more of an issue with investment accounts that are held jointly, but sometimes people in their current account might keep tens or even hundreds of thousands of dollars. When you as an adult are added on to your parents' account, added on joint, and this would be true where we're talking about bank account, investment account, or even with real estate. When you as an adult child are added on to it, apart from the tax implications of things that I already went through, absent some record evidence to the contrary, you are not put on there for your own beneficial interest. You're only on there as legal joint owner on that account. When parent dies, you actually hold whatever is in that account as a trustee for the beneficiaries of the estate. Now, practically, in families that get along, it probably doesn't matter much. You would continue to take care of that, like you'd pay the funeral, you would do all the kinds of things that are necessary to begin the administration of the estate at the very least, and then there'd be some kind of an accounting for that, and you wouldn't actually pocket the cash yourself. You'd share it with your siblings, whoever is the beneficiaries of the estate. That comes out of a case that was confirmed out of a case about a decade or so back, which went to the Supreme Court of Canada. If, it's called PCOR, if anybody's dying to go read 300 or 400 pages. If in that situation, truly you were intended to be the beneficial receiver of the interest, then you could prove that. If you had evidence to that effect, you could prove that. Or if that's what your mom wanted to do in the first place to help out things, she could make a firm statement to that effect so that there's no confusion about it in some kind of an official way, so there's a record of that, in which case, yeah, it truly is yours, as opposed to holding it in trust for the estate. Okay? There is tax on the disposition to the deceased person for the deceased person's interest in the property, okay? Not to you as the continuing joint owner on it, which could get a little bit messy, complicated, but it is actually the deceased person whose portion of the interest is disposed, mom's interest, not your interest on that property. So the tax is actually borne by the deceased person, the deceased person's estate, if there is income triggered by that event of her death. Prepaid funerals, well, prepaid funerals is a contractual arrangement between you and the funeral operator. And so it really is it's a business transaction as opposed to insurance. There is something which is called an eligible funeral arrangement, where if you've paid money to a funeral provider, and I think this is true of both cemetery plots as well as funeral directors, if you've paid money which is held on deposit, and that money is accumulating value to pay for the later funeral, then if it fits the requirements of an eligible funeral arrangement, which is something which is actually defined in the Income Tax Act, then the interest which is accumulating on the deposited funds is not taxable. I believe that's a treatment. Great, I'm on tape saying that, and somebody's going to get me on that. But look up eligible funeral arrangements if there's money on deposit. If you've outright paid for the thing, and then it really doesn't have any tax implication whatsoever, but if it's a deposit towards the eventual payment 5 or 10, who knows how long, down the road, then if it qualifies for eligible funeral arrangement, my understanding is that the accumulating amounts are not taxable in that case. Okay, so how much can you leave a disabled dependent before they are penalized on their support payments from the Ontario government? Right, okay. So the main program supporting people with disabilities in Ontario is the Ontario Disability Support Plan, ODSP. And this, again, it's quite a complicated, so I can't give you a really simple answer on this. The general limit for asset ownership for someone who is receiving the ODSP is, on an individual basis, $40,000, or for a couple of the benefit unit, as it's called, $50,000 of directly owned property. But there's all sorts of exceptions to that. If you own your residence, that's an excluded item. A vehicle is excluded. There are a number of things that are excluded from that. You can have up to $100,000 held in trust for your benefit before you start getting clawed back on your ODSP. And then where this goes to as a true planning opportunity or requirement is, if a trust, having said the word trust just a moment ago, if a trust is set up where the benefit of the person who is the disabled person is completely in the discretion of the trustee of the trust. Remember my triangle, the original money here, trustee, beneficiary. If the trustee has absolute discretion over the amount and the timing of the distribution of the property over to the beneficiary, then the ODSP administration will not consider that particular property held in trust when it determines the entitlement of the ODSP recipient. So that's it. You'll hear the term Henson Trust because the first case where that was ruled upon was a person by the name of Audrey Henson. So Henson Trust is basically a discretionary trust. And if you have someone who's got a disability who's receiving the ODSP, then you should look into that as one of the ways that would more effectively transfer property to them where it's available to them to use, but it does not affect their ODSP entitlement. And just I'll throw in one more part of that. People might say, well, I'm wealthy, let's say. I'm not concerned about the ODSP, which is no more than $1,000, maybe $1,500 a month. So not an amount to sniff at, and particularly for people who have a disability, it's critically important. But if you're particularly wealthy, you might say, oh, well, we've got $1 million estate here. Why be concerned about this fairly small amount coming from the government? Where you are particularly concerned about it is where ODSP qualification has other things that associate with it. So for example, and this is an actual case that I dealt with 20-some years ago, the woman who I was dealing with, she received an inheritance as a referral through the CNIB, Canadian Institute for the Blind. She received an inheritance from a distant relative that put her over top of the asset levels for the ODSP, which was unfortunate in itself. But the other thing it did is, because she was ODSP recipient, she was front of the line for getting certain types of procedures, and she was due to get cataract surgery in the next month. Because she received these amounts, it knocked her out of ODSP. It also took her rent from $150 to $1,000 a month, and it took her out of the waiting line for the cataract surgery, and she had to wait for almost a year to get the cataract surgery. So there are other dominoes that can fall apart from the dollar amounts to be aware of, so make sure that you do look into it where you've got disabilities involved. I think that we're probably as far as we can go with time. I really appreciate everyone. I think Doug's going to step up here. Really appreciate everyone's attention here. Thanks.